Good afternoon, guys. My name is Alina Sheltsova. I'm an immigration attorney from New York. And today we're going to have, as promised and advertised, our live, where I'm going to, of course, provide you as always some updates, some tips. Mostly we're going to discuss immigration court. We're going to also talk about processing times, USCIS processing times, and I'm going to talk about immigration waivers. And of course, we're going to talk about the questions and issues that are interesting to you. So please say hi, first of all. Let me know where you're watching from. I'm always very happy to find out where my subscribers, my audience is coming from. Please type up your name or however you want to be addressed to. Say where you're watching from. And of course, don't forget your questions. Now you have an opportunity to ask me questions for free. So hi Kiber, Virginia Beach, hi Ida, hi Tan, hi Eric, hi Armal, hi Dmitry from New York. Yes, Los Angeles, New York, Virginia, we have so many different states. I know there are people watching me sometimes from other countries. Hi Julie, hi Anita, hi Yaya, hi MD, North Dakota. You know, this is probably one of the states I have never been to. I've been to many different states because I used to represent young lawyers with American Bar Association, and we traveled a lot. We traveled to many different states in the United States, and I've been to southern states and northern states in California, San Diego, San Francisco. I loved it. You know, from New York, it's a very long flight, but I have never been to North Dakota, I'll be honest. Hi, Agnes. Hi, Kuna. Hi, Easy. Hi, Ida. So let's see. Hi, Obeng. And please don't forget your questions. So let's start. I think I'm going to start now, easing to our presentation, what I want to share with you today, and then we're going to go back to your questions. Well, first of all, I wanted to let you know that this one, as I mentioned, is going to be about some practical tips, practical information that you as an immigrant in the United States or somebody that is your family member perhaps may actually use. And you can use this information so that it helps you to make your decisions about your case. You can also go back to your attorney and say, hey, maybe it's a good idea to do things this way, that way, or you can just do some more research online. I just give you leads, and then you decide however you want to use them. Of course, it's not what we would say legal advice, because legal advice can be given only between attorney and client when attorney and client relationship is built during confidential consultations. But these are, I would call them tips, right? What to do in this or that situation. And the first situation I wanted to discuss with you would be removal proceedings. And currently, as you are aware, perhaps, that this administration favors what's called prosecutorial discretion. Prosecutorial discretion is when the government or prosecutor helps to resolve the case, not just by taking it to trial, but also perhaps giving you some leniencies, or perhaps agreeing with your lawyer on some points about your case, or perhaps agreeing to stop your case or dismiss your case, right? Basically, prosecutorial discretion is the power of a prosecutor that they can use that affects your case. I would say positively rather than negatively, because you wouldn't ask for it if it affects your case negatively. So here I would like to mention one more time, and I spoke about this in my other videos, about particularly interesting tool of administrative closure. Why am I talking about this? Because, guys, let's face it, many of you may use it. Administrative closure is a tool that helps the court to control the calendar by removing the case from the active calendar, but not quite killing it and stopping it. It would be useful to many of you who do not have particularly strong cases in immigration court, or perhaps they have to wait for some time for some strong case to come their way. For example, they're waiting for that U visa to be decided, or they're waiting for the child to turn 21, be US citizen child, turn 21, and being able to sponsor them. Or maybe they're waiting for the spouse to become a citizen, and then they will be able to sponsor them, because right now their spouse is only a green card holder. And as you may be aware, green card holder very often cannot sponsor directly for a green card non-citizen because of the different bars to adjustment of status that non-citizen is going to face. So there may be situations when that administrative closure may be very useful to you. However, what I learned is that apparently some prosecutors do not want to agree to it, rather offering you a dismissal, entire dismissal of your case. So you will be free. You think, I'm going to be free from the removal proceedings. It may be or may not be a good idea for your case. Why? Because you have to take into consideration that, first of all, when you are in proceedings, and most of you probably having asylum pending proceedings, so listen up. If you are in removal proceedings, waiting for your asylum case to be resolved, if you agree to administrative closure, for example, first of all, you're keeping your 1-year deadline preserved. As you're aware, perhaps not, to file your case within 1 year of your arrival to the United States, so your entry to the United States, is crucial for asylum cases. So when you file your application, first perhaps with USCIS office, right? When you were waiting for your interview before you were transferred to court, this is when that 1-year deadline is grabbed, when it's preserved. Now, if you are now in immigration court and ask the court just to administratively close your case, you're preserving that 1-year deadline. And it's extremely important to understand that if in the future you would like to restart your case again, your 1-year deadline will be grabbed, right? It's there. You met it. If, however, you would like to close your case in immigration court, and later you say, you know what, I would like to again file for asylum, you may face an issue of 1-year deadline because your case that you originally opened will be closed, and you will be essentially filing a new case, and you will have to meet that 1-year deadline again. Very important point. But that's not the only important point. The other important point is when a case is administratively closed, you are still eligible for work permits or employment authorization documents, and you can file and refile them because your case is not disposed of like it happens with dismissal, but it just paused. So you need to understand this difference. There is a huge difference between dismissal of the case, even though it sounds like, great, I'm going to be free of this immigration court, I don't need to worry about it anymore, right? But then you're also going to probably lose your employment authorization. In contrast, when you have case just administratively closed and not dismissed, you still can file and renew your work permit. It may be very important for you because if you rely on that work permit to have your job, you're not self-employed, for example, even though self-employed people should have work permits as well, because self-employment is employment. But of course, it's much harder for those who are not self-employed. You guys need those work permits to find legal employment. Sometimes my clients work in hospitals, for big corporations. Immigrant is not necessarily somebody who has very simple jobs that don't require a lot of training. A lot of immigrants actually have very complex jobs that require license and training, and they're not going to be employable without that employment authorization. So before you make the decision of what is best for you, dismissal or administrative closure, you have to discuss this particular point with your attorney, point of your work permit, if it's going to survive that prosecutorial discretion that may be offered to you. Also, sometimes, for example, you are somebody who is hoping to fix your immigration case based on adjustment of status due to marriage to a U.S. citizen. You also have to take into consideration deadlines. What I'm talking about? I'm talking about the fact that currently it takes, in New York, at least 10 months for I-45 to be considered in New York. We're not even talking about service centers, right? But it takes even longer if your case is going to go first to a service center, or it's going to be in a national benefit center, or if it's going to be stuck somewhere in between and transferred between the offices, while the judge may have a certain date for you. So at times, right before the hearing, prosecutor can come into you and say, I offer you dismissal. You can go to USCIS and fix your case there. But it may take you longer now to fix your case with USCIS than it would have been with a judge. All right. So whenever you have an option of filing for adjustment of status with the immigration court or with USCIS, and the government says, we're going to close the case for you, you also have to remember that processing times right now are crazy. And you may be better off in immigration court, even though the immigration court, of course, immigration courts are also overbooked, but you may have a certain date, provided it's not going to be rescheduled, which may be closer than the processing times potential date. Very, very important to know that. Now it's going to take me to my next point, the processing times. I promised you at the beginning to talk about the processing times, and here I'm going to talk about the real life processing times that I've seen in my practice. Not something, there are rumors or anything like that, what I've seen. Work permits take anywhere from 6 to 9 months to receive. If you're filing based on adjustment of status pending, extremely long. Work permits processing times increased by 2.5 times. If before we would get a work permit for somebody who's filing based on marriage to a U.S. citizen within 3 months or so, now it takes 6, 7, 9 months to receive that work permit. I-601A waivers. Guys, this one became crazy. The processing times increased to about 1.5 years, 2 years. I-601A waivers. Official statistics currently stands at 21 months to 27 months for Nebraska, and there is a second service center that is considering them. That one has 30 to 39 months, even longer. So whenever you are worried about what happened to my I-601A waiver, check out your processing times first, and you, of course, be in shock that it takes so long. Before, we could easily say that it takes anywhere from 6 to 9 months. Currently, it takes way longer. I will tell you that so far I have been lucky, and it takes about a year and a half. But official statistics tells us that it takes way longer, about 2 years right now on average. 2 years to get a decision on I-601A waiver. And it's an extremely important tool, just because we do not know what's going to happen with immigration reform. But I-601A waiver helps so many people to fix their status if the only issue they have unlawful presence. Usually, you will see a situation when a person came to the United States between the ports of entry. Now they're married to a U.S. citizen. They have family life ties. They have a strong hardship case, but they cannot get a green card in the United States. Why? Because they don't have a necessary condition for adjustment of status. They cannot show that they were inspected and admitted or paroled into the United States due to that entry between the ports of entry. And now they have to get their visa overseas. But if they leave the United States, immediately they become inadmissible due to unlawful presence time. New issue, right? Unlawful presence time that they accumulated in the United States. And to resolve this situation, they will need this I-601A waiver, which a person can file for while they're in the United States, get it approved, and only then travel to their consulate in the country of their home country, and then come back with a visa. So that's what I-601A waiver is. I have videos about that. I have information on my website about this, www.sheltsova.com. This waiver has been around for almost 10 years. Great tool. Many people stopped pursuing this tool because first of all, they were relying on promises of immigration reform, which still may happen, but taking into consideration crazy processing times, I would say that go for it. In 2 years, we will know if immigration reform is going to happen or not. And if you don't go for it, you're going to waste a lot of time. Time that's been already wasted, I'm sure. Another concern with this I-601A waivers is that people say, well, but my consulate is so strict. How do I know I will be able to come back? I'm going to tell you that. Even though my clients always can come back, I've never ever had a case where a client for whom I handled I-601A waiver could not return back and got stuck there for a long time. I had one case where a person got stuck for a little bit longer than we planned for, but it was due to misunderstanding on behalf of the consulate. It was resolved in a matter of weeks. I've heard cases where people say that they're permanently inadmissible, they left the country and cannot go back. But this was a result of not checking client's background and not preparing the client for the consulate interview. That's it. Because what happened is that I-601A waiver waives only unlawful presence, but there are other grounds for inadmissibility that can come into play. For example, claim of U.S. citizenship. No waiver for that. Of course, if you claimed U.S. citizenship, you should never file for I-601A waiver. Perhaps cancellation of removal will be a better option for you, or U visa if you're eligible. Okay? Misrepresentation of fraud. You entered the United States initially using someone else's documents. I-601A waiver will be a bad choice for you. Okay? So that's why things like this happen. They just don't happen randomly, in other words. It's not that the consulate is not going to like you. No, it's either you're admissible or you're inadmissible. And they have to abide by the rules and regulations. And that's that. Don't forget, I-601A waiver is a great tool. Keep in mind processing times. And now also I wanted to mention processing times for citizenship. When you're planning your life ahead, right? And thinking, oh, I'm going to sponsor my spouse and this and that, you would like to know how long it's going to take you to wait to become a citizen. Currently, New York is going to take you about a year. Okay, there was time when it was only 9 months. Now it's about a year that you will be called for the interview. And hopefully, if everything goes well, after the interview, within weeks, you're becoming a US citizen. Now, remember that lawful permanent residents can still start the process for their spouses. They can start the first half of the process. They can file I-130 alien relative petition for their spouse. You don't have to wait for that. Lawful permanent residents, parents, can start the process for their unmarried children who are over 21. Some people are confused about that. They think only US citizens can sponsor their sons and daughters. Sons and daughters are children who are over 21. No, lawful permanent residents can do that too. There will be adjustment of status issues, but again, you may qualify for I-601A waiver. And of course, I-601A waiver is a very interesting topic. I can talk about it for hours. But if you're interested in it, just refer to my website and videos, and then you can have a consultation with me or other lawyer and see if it's a good option for your case. Okay? So these are the main points I wanted to cover before I will start answering your guys' questions. So let's go ahead and see. Hi, Ada. Do you represent clients with immigration to Canada? Kesley C. No, I do not. I'm licensed to work with immigrants only in the United States. And if you'd like to go to Canada, then you will have to find a local lawyer or immigration consultant. I know that immigration consultants, they're a licensed once in Canada, and they're very effective as well. Just a matter of finding the right person, for yourself. And of course, immigration to Canada in some aspects is more forgiving, and some aspects are not, but I'm not qualified to address all the issues, but all I can tell you is that for Canadian immigration and what I observed, and it's not the lawyer's opinion or anything, they're very strict on criminal records, very strict. Even a little criminal past can really disqualify a person. Hi, Akuna from Philadelphia. Hi, Issy. Any news about Dreamers Act or essential workers? Guys, today is a day off. And from what why it's important is because the Congress, everything is shut down, right? They don't really update us. So as of today, there are no real news. Perhaps if there is something tomorrow, I'll post it on my community board. Maybe I'll have another live if there will be some good news, absolutely. But so far, nothing new, unfortunately. I know that, some people, important people in the country, we're all important, but some have also power of changing lives, and their opinions listened to more than others, um, advocate for doubling the legal immigration numbers. I know that there will be some meetings between various officials to discuss, but we don't have any specific proposals, no legal proposals, and no answer as to what's going to happen with the reconciliation provisions. Are we going to go forward? Democrats are going to go forward, overruling the Senate parliamentarian, or they will just give up. No news yet. We'll see. Sometimes they say no news is good news. Hi, Tariq. I would love to see a video about EB2 visa on your channel if you are doing this. Hi, Atan. I have some information about EB2 visa on my website. You see, EB2 visa is such a complex topic that I don't think one video would be enough. And if you are considering applying for it, of course, first of all, I should tell you that it will be probably wise for you to consult with an attorney, but also your employer has to consult with an attorney, because your potential employer will be the actual client during the majority of the time. And it's the employer who hires a lawyer and deals with an attorney, basically. EB2 is an employment opportunity for somebody who has some skill, education, to be sponsored for permanent residence or green card by an employer in the United States. I can briefly tell you that the main things to watch out for would be labor certification process. And I do have an article about this on www.sova.com. Labor certification is very interesting and very rigid, very strict process that has to be done by an employer who would like to sponsor an employee. Basically, they have to test the market and show to the satisfaction of the United States government that they could not find a U.S. worker for the same position. If a qualified U.S. worker applies for the position that is offered to you, you will not be able to be sponsored. Also, another point to watch out for would be the timing of everything, of all the filings. During this process, employer, or rather lawyer, has to make sure they comply with all the deadlines and file all the documents on time. What else to know? Ability to pay, that's another big issue. Ability to pay is when employer must show that they have enough money to pay you your salary. And your salary is not just a salary that comes out of nowhere. Actually, there is a prevailing wage determination that has to be obtained from the Department of Labor at the very start of the process. And the government, again, is going to tell your employer how much they should pay you working for this particular employer in this particular area with doing this particular job duties. So that's what EB2. Complex process, very heavily regulated, no room for mistake whatsoever. But of course, if it works out, 9140 is approved, then there will be an issue of whether or not you can adjust. I-601A waiver, by the way, can help in this situation as well. Yeah, so it's a lot to cover, a lot to talk about. Maybe one day I will focus on one particular aspect of it. What about the asylum case pending since 2016 without the interview? What about it? Please let me know what is it that you would like to know. It's not a unique situation. Many cases are pending for that long. You have to prepare for your interview. You will be called for the interview soon, this year, next year. Are you prepared? Do you have your statement that is without mistakes, very easy to read, makes sense? Did you comb through your history and through everything else and gathered all the evidence? You're going to have one chance to present your case before that USCIS asylum officer right? Do you have that? Are you prepared? If you really would like to and you have strong reasons for it, you can even expedite your interview. It's possible. But I always tell my clients who ask me about this, make sure it's going to be the right decision for you. Because if your expedite request is granted, you're going to have only 3 weeks notice max to show up for that interview and being prepared. Do not ask for it while you're not prepared. And then you have to understand the risk that even though you will be afforded the interview and your ability to present your case before a USCIS asylum officer, it does not mean that your case will be approved. And then, if it's not approved, you will be referred to immigration court. And now there is a big difference. While you're waiting for your interview, you are not in the removal proceedings. You may still, in theory, apply for advanced parole and travel outside of the country, not to your home country or country where you're asking asylum against, but some other country. Once you're in removal proceedings, no travel. Okay? That's one of the first big differences. And of course, the pressure of the removal proceedings, you may be removed. So do you want to potentially speed up that event? You have to be careful. Hi, Diana. Chance of applicant joining Board of Immigration Appeal motion to reopen. Married to a citizen, have kids, have I-130 clean background. Depends on the hardships. And what happened before? If it's Board of Immigration Appeals, there was an appeal. It means that your spouse lost their appeal before, right? So, chances depend probably on the office, like what happened, what the record shows. Was the spouse's case lost because of some technicality, or because the spouse was found completely not credible, or maybe there was even some misconduct or something. Was there fraud involved or not? And why are you reopening the case? Like, what's happening? Is it so sponte hardship? I would suggest that you discuss with your attorney what's called unpublished Board of Immigration Appeals decisions. They usually give you good clues as to when the case may be reopened. Okay. If you can show strong hardship case, opportunity to fix one's status in the United States, why not? Go for it. Try it. I will always say that if you have a choice between reopening your case and going for two waivers, because if somebody has an order of removal, there's opportunity for them to fix their case sometimes can be the waivers, two waivers route, I-212 plus I-601A. You always have to try to reopen your case first. So by itself, it's the right decision, in my opinion, even though I do not know your case. I'm just judging on general facts. And the chances, of course, depend on how strong the case is. And sometimes it's a chance. It's really weird. I saw some lawyers posting. We have this community board by American Immigration Lawyers Association, and I saw some posting sharing the experience, saying that their request for PD is denied, even though this administration said that they are very favorable to them. And the person says, I do not know why it's denied. Other lawyers said in very similar situations, PDs were approved. So what is it? I feel like sometimes it's a chance. Even though your attorney may do an excellent job, your application for something may be denied because in many situations, it's subjective. Perhaps it's also the way your lawyer talks about you, whatever evidence you can bring. Here we talk about advocacy, how to present the case in the best light, right? You can say, well, this is a pencil, it's yellow, it has this green writing on it. Or you can say, this is an amazing tool that helps me to create unbelievable stories or art pieces. However, right, there is a difference in presentation sometimes, which I feel like sometimes makes a big difference. Hi, Has. What is the tip for calling the 800 number of USCIS in order to speak to a live correspondent? Oh, I had the posting about this. Maybe I'll repost it on community boards. There was like a line of different prompts, and I don't remember them from the top of my head. I refer to that cheat sheet. And you can like 1122, and they're gonna give you a live person. I'm not sure if it's still working, but I'll make myself a note to do it. Community board, how to reach a live body on USCIS website. Yeah, I did have that, you know. It's a good question. Sometimes you feel like you spend there for forever. Hi, Aviata. Hello from Naples, Florida. I love Naples, Florida. Oh, thank you. I'm waiting on my I-601 to be approved. It's been 6 months already. Do you think it will take longer? Oh, yeah. Oh, yeah. We just talked about this. You're not going to like it. The processing times show average time of 24 months. It's horrible. Also depends on which center grabbed your waiver. One of them has processing times of 30 to 39 months, and Nebraska has 21 and a half to 27 and a half. So I'd say a year and a half. A year and a half will be a good result. But also, you see, when we talk about processing times, it doesn't mean that in every particular case they will be the same. Sometimes you get very fast results, and sometimes they're even going to be pending beyond this posted processing times. It doesn't mean there's something wrong with the case. It can be, again, some bad luck, you know. Somebody worked on your case, maybe you decided to leave, forgot it somewhere on the shelf. Follow up with them. Not now, maybe in another 6 months, if you still don't have a decision. Hi, Sukhinder. I'm good, thank you. Hi, Anna. Hi, Alina. Is there going to be a problem if I had a theft charge, paid 500 fine 10 years ago, and now applying for citizenship? Anna, I suggest, first of all, that you get a certificate of disposition for this situation and consult in private with an attorney, okay? Depends on how the charge was resolved, from which state. I've seen, in which was at some point crazy, that petty theft convictions from Georgia used to be regarded as aggravated felony. Thankfully, the higher court finally resolved this issue, saying they're not. But it was insane. In New York, usually when the case is dismissed, if a person rather did not on a record pled guilty, right? In the case it got dismissed, in New York at least, then this shouldn't be a problem for a person. Each state has its own definition, and the language matters. Okay, definition of a conviction of a crime, what constitutes a crime, and also the final disposition. If the person usually pays a fine, it means they were found to be guilty, right? That's the thing. But again, it doesn't mean that in your particular case it will be a problem. I would suggest that it also may be something that qualifies as a petty offense, most likely. I don't know. Take a certificate of disposition and show it to an attorney, and you will know for sure if it's going to be a problem or not. Okay? Most likely, if I had to guess, I'd say no, but again, it's not a legal consultation. You should not be relying on what I'm saying here. It's just a point of start to your research, all right? Very, very important. Can someone in removal proceedings suggest status of married to a permanent resident? Most likely not. If the person is in removal proceedings, it means the person potentially is removable, right? Most likely, they have some issue with their underlying lawful non-immigrant status. And if that is the situation, adjustment of status, if a person is just married to a green card holder or just green card holder, will be not available to them due to 245C prohibition contained in International Nationality Act on adjustment of status for someone who failed to maintain their lawful non-immigrant status throughout their entire stay in the United States. However, if a person had a legal entry and their spouse is going to become a U.S. citizen and becomes a U.S. citizen, then adjustment of status will be available. Now you can play this whole thing back that we're just talking about and see if perhaps administrative closure will be something that is useful in this particular case, right? But again, not every situation is the same. You also have to always show that you had a legal entry. You were inspected and admitted or paroled. Some people, they don't have that. So marriage to U.S. citizen not going to help them either. They'll have to go for a waiver. And again, administrative closure may be helpful here too. Hi, Jean. There are thousands of poor people coming from open borders. Send them back. We need people to come here that could add and not take. Why does immigration make it so hard for white people to come here? Whew. Well, I disagree with a lot of those statements. I would omit completely the reference to the person's color, which is not important when we talk about immigration. Thousands of people coming from the borders. They do, but the reason you have to ask yourself why they're coming. I don't think they're coming because they're happy where they're at, right? Very often, not only they're not happy, it's dangerous for them to stay there. From what I understand, you're referring to the southern border situation, and I have to tell you that they're not coming, most of them, just because they want to hang out here, and they do work a lot, and they are very hardworking people. They're coming because this is their last choice to save their lives and their children's lives. I know that firsthand because I work with people from El Salvador, Honduras, Guatemala, and the stories they're telling you will make you not sleep at night. And I don't think that they made them up. I don't believe that the little kid can make up the stories that they're sharing. I'm going to tell you. So I think what happens is that it's the issue of helping the countries where they're coming from to be safer and more economically stable. And if that would be the focus of the world leaders, then we will be able to resolve the global migration crisis much better. Not just by kicking people back and threatening them and calling them lazy and so on and so forth. And as to the rest of your statement about people of certain color to come here, I don't think that the rules differentiate between the color. They're the same for everyone. Basically, if you follow, which we all should, the path of legal immigration, it's hard to become a U.S. citizen or permanent resident in the United States because the opportunities are limited. It's either family immigration, investment, or business, and sometimes humanitarian avenues, right? So that's what we're focusing on legal immigration. That's why the immigration system has to be reformed. Not just make for white people, but for all people easier, provided that they can establish family ties, their contributions to the United States. If you would ask me, I would give work permits to anybody who would like to work. But then if they don't pay taxes, I would take them back, right? Or, for example, if you worked and lived here for 10 years, you paid taxes, you have family ties, you should be able to file for a green card in the United States without the need facing the judge in cancellation of removal. Why it's not done, guys, I do not know. That's why we have millions of videos by different lawyers discussing all this, legal proposals. And each administration is promising something different and nothing is done. But the United States immigration system needs some serious rebuilding. It's not even reform, it's rebuilding. You need to address the issue of global crisis. And by the way, global crisis is not only true for America. Europe has the same issue. Lots of people from different countries and continents are coming to Europe. What's happening in the world? It's crazy, right? But it's a fact. But what's interesting is that this is not a new issue. Several years ago, 5-6 years ago, I was a representative from the American Bar Association to the United Nations. And already at that time, there were reports of global migration problem. They already identified the causes, which would be climate change, one of the main things, actually, believe it or not, conflicts, armed conflicts, economic problems with economies of certain continents, global economies. And they said that it's just going to be worse and worse. But from what I've seen in all these years, Nothing was done to address it by the leaders. All we see is building fences and threats. But that's not how you address this issue. I don't think it's going to be addressed through fences and threats of not do not come here. People are still going to come. They don't have a choice. Hi, Bank. I was in removal proceedings, but my asylum proceedings has been terminated by the immigration judge without prejudice. So in my case, how will I be able to get a green card and renew work permit? I do not know. I do not know your case. I do not know if your removal proceedings terminated. All it tells me that you're no longer in immigration court, and then you have to see if you qualified for adjustment of status with USCIS. Usually, you have to have basis for the green card, right? And then the green card application and qualifications are going to be checked with regard to the basis. Are you married? Is it a real marriage? Or are you special juvenile? Is your ISO 60 approved, for example? Are you a VAW applicant? Did you meet your qualifications? And the second step, are you adjustable? Now, since you have the basis, can you build on that basis your green card application? Do you have disqualifying criminal convictions? Or maybe you committed misrepresentation or fraud, or you do not have legal entry. So that's the analysis that goes into play. If you were in removal proceedings, I think you had a lawyer and you should have discussed it with your attorney, right? If you would like to discuss it with a different lawyer, please call us. I'll be happy to review your case and see what is it that the situation is and what can be done. Hi, Nilza. Can I apply for non-immigrant and my national interest waiver? What is it? If I overstayed my visa for more than a year and don't have a qualifying relative, can I apply for I-601? All right, national interest waiver is that what you're referring to is completely different from I-601 waiver. National interest waiver is applied in connection with employment immigration when you do not want to be subject to labor certification, right? I-601 waiver, if you open the form I-601, you will see that it's a generic form that is used by USCIS immigration, outdated, to waive all and any possible grounds of inadmissibility, almost all of them. So I-601 form will be used to waive such things as misrepresentation of fraud, for example. The same form will be used in connection with other grounds of inadmissibility. So if you overstayed your visa, usually I-601 is not going to help you. It's not possible to file I-601 inside of the country and this way to resolve the overstay issue. That's why you may want to learn more about I-601A, but you need to have qualifying relatives for that. Okay? I know it's hard for me perhaps to consult somebody, and it's not a consultation, again, general advice, talking very fast, but all I can tell you that I think you read something incorrectly about national interest waiver and I-601, and it's not possible currently to receive a waiver within the United States for overstay. Not possible. I wish it was possible. Then you wouldn't have to travel outside of the country at all. Hi, Yancy. How are you? I'm all right, thank you. When you have military PAP, how long does it take to get a work permit? Is it faster than other cases? Yeah, it should be faster. It should be faster. If you were granted PAP, then hopefully, are you filing for adjustment of status? If you are filing for adjustment of status, and I don't think it's going to be faster than other cases. If you're just filing for the work permit, it may be a little bit faster. Okay. How far NVC reach on case reviewing? Not sure. Not sure what the question is. It depends on if you submitted all the documents and DS-260 form, because NVC starts reviewing someone's case only after they have all the documents submitted and the applicant submitted DS-260. It depends on each particular case. Hi, Yuka. Can I enter the United States after my 10-year bar expire, or do I also have to apply for I-601? Thank you for providing us all this information. Why did you have 10-year bar? Was it because you were previously deported or just because you overstayed your visa? If you just overstayed your visa for more than 1 year or just accumulated more than a year of unlawful presence time, and there are no other grounds for inadmissibility, when you're going to be filing for the US visa, all it means after you serve your 10 years is that you're no longer inadmissible based on that unlawful presence bar. But you may still have to apply for a waiver if you're inadmissible on other grounds. Okay, that's the difference. And of course, when you're filing for the visa, if it's a non-immigrant visa, you also have to worry about proving that you are not an intending immigrant. Okay, so let's say you decide after 10 years to come and visit your family member on B1, B2 visa, right? So you're no longer inadmissible based on previously accumulated unlawful presence. But the government, the consular officer, may still say, well, you previously stayed in the United States for 20 years, illegally. Then you left the United States, stayed for 10 years, and now you say you would like to visit your daughter in the United States. Well, we think you're going to stay in the United States, so we're not going to give you a visa at all. Possibility. Or what if your daughter actually filed I-130 for you, and now you're coming based on a family petition, so that concern of you not having an immigrant intent is not even an issue because you're filing for an immigrant visa. The government may turn around and say, if this is the case, they say, yes, you're right, you don't need a waiver anymore to come back earlier than 10 years. But we found that previously you misrepresented yourself, blah, 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 to USCIS, so you misrepresented some important fact in your immigration applications. So you still need a waiver, but now for a different ground of admissibility. And that waiver will be filed on Form I-601. So you may still have to file a 601 in certain situations, even if you served your 10-year bar. Okay, that's what it's all about. Hi, how long does it usually take for I-601A waiver to be approved? We just talked about this. The processing time became outrageous, guys. I would say that anywhere from 1.5 to 2 years. That's what posted on the website. I thankfully have not seen crazy processing times, what they also posted of 39 months, but it's posted. So some cases are pending for that long. So guys, that's probably going to be the end of my today's presentation. I was very, very happy to see all of you joining me. Thank you for your questions. Thank you for participating. Hopefully you're going to find some useful information in all this 48 minutes of me talking nonstop for you. I would suggest that you always, before you make decisions about your case, any decision, whether you're filing something or you're making a choice in removal proceedings, first of all, of course, you discuss it with your attorney, do your independent research. As I said at the beginning of my presentation, that sometimes something sounds like a great idea, but it will affect you in a way that you do not expect long term. And you have to take this into consideration. So please post your comments after this video is going to be over. I'll try to answer them, or at least direct you to where you can find the information and begin your research. Stay healthy and safe. Share this video if you don't mind. Subscribe to my channel if you haven't, and I'm going to see you soon.